Hello everyone and welcome to my channel Decode VR Act. So in this video I will going to discuss the concept of presumption given under the basically important topic under the Indian Evidence Act 1872. So what is presumption? So presumption is basically nowhere defined in the Indian Evidence Act. So in simple word we can say that presumption is a inference which we drawn from the proved fact. Basically some facts are already proved and on the basis of that proof fact we infer another fact. Okay, there was a case of MS Narayan versus state of Kerala. The same thing is held in this case. In this case the Supreme Court held that presumption is an inference which is drawn from the any proved other proved fact, and it is a rule of law which allowed the court to make inference by process of probable reasoning drawn from the fact judicially noticed by the court or admitted before it. Okay, so basically presumption is not only a piece of evidence but it basically absolves the party from proving certain fact. If if certain facts are already proved and the court presume certain fact, then that party are absolved from proving that fact. Okay, so basically presumption are of three kinds. The very first is presumption of law, the second is presumption of fact, and the third is mixed presumption of law and fact. Presumption of law and presumption of fact are valid in India, but presumption of fact and law, that it is not recognized in India. Okay, so what is presumption of fact? Presumption of fact or may presume, it basically means it is defined under section 4 of the Indian Evidence Act. It said that if the court basically here there is a discretion on the part of the court to accept or not to deny the fact which is brought in front of the court. Here there is a discretion on the part of the court basically. So the example of this is section 1990A of the Indian Evidence Act. You go through this. Basically section 90A was added 2001. It basically said the electronic document which is 7-year olds, and section 90 is about a document which is 30 years of old, 30-year-old. Okay, so it is a discretion on the part of the court to accept the that document or not. Now the next thing is shall presume. Shall presume basically this is basically of two types: rebuttable and irrebuttable. Rebuttable basically means that here the court presume a fact, okay, and the another party is entitled to disprove that fact. Okay, so this is rebuttable. Irrebuttable basically means here the court presume the another fact. Here basically irrebuttable presumption is also called as conclusive proof. Here the court, if we assume any fact, then the another party are not entitled to brought a thing against it. Okay, if the court accept any fact, then it is considered to be proof, and no other party, basically the opposite party, are not entitled to brought the material which disprove the thing. So this is all about the presumption. Thank you so much for watching this video.